Good morning, everyone. My name is Susan Bockham, and I am the moderator today for the first collaborated joint endorsement interviews for the Veterans in Politics, Nevada Democratic Veterans, the Military Family Caucus, Nevada Veterans Association, and the Armed Forces Chambers Pact. I'd like to big thank you to our sponsors, Monzu Italian Oven and Bar, for allowing us to use their facility today, Stephanie Phillips, candidate for United States Senate, and an anonymous donation on behalf of Jerry Willick. This morning, we are going to be interviewing two candidates for District Court Judge Family Division, Department N. We have Judge Paul Gaudet and attorney Kerri Maxey. Each of our panel members are going to quickly introduce themselves. They will let you know which organization that they are with, and they will each be posing a question to each of you. Once they introduce themselves, then I will have you guys do a brief overview of yourself and why you're running. Jim Jonas is going to be our official timekeeper today, and he's going to explain exactly how that works. And he is very tight as a former member of the military on keeping good time, so we appreciate him being there. And of course, we thank Steve Sanson for being here as well today and facilitating this on behalf of everyone. Mr. Jonas.
Jim Jonas, Director of Veterans in Politics. You, both candidates, you'll get 1 minute to introduce yourself, why you're running, why you're asking for our endorsement. And then when you are asked a question by panel members, you'll be given 1 minute to respond. You get a yellow card at 15 seconds, and the red card, I cut you off. Thank you.
Andre Haynes, founder and CEO of the Armed Forces Chamber.
Patsy Brown,
President of the Armed Forces Chamber.
Donna Darden, I'm here with the Veterans for Democrats.
Rob Lauer, Veterans Politics.
Frank Friends, Veterans in Politics, Family Court Watcher, and owner of Friends and Family Firearms.
Kellogg with the Democratic Party.
Barbara Leuschen with Veterans in Politics.
Okay. Judge Gaudet, if you'd like to tell us about yourself and why you're running, please go ahead.
Thank you, Judge. I appreciate it. My name is Paul Gaudet. I'm a 32-year resident of Clark County, Nevada. I'm a 32-year practicing licensed attorney in the state of Nevada. I'm currently your judge in Department N of the Family Court. I was appointed to begin my service in late March of 2023. Is it loud enough? Late March of 2023. I've now been on the bench for about 11 months. I've been told I'm doing a pretty good job. I try to be as efficient as I possibly can. I try to get people through the system as quickly as I possibly can. Jim previously said, make a little statement on why you're running. Well, I'm going to tell you why I'm running, and it may sound pompous, but I listened to other questions that were asked in the interviews before. The reality of the situation is Las Vegas, Clark County, Nevada has been very, very good to me and my family. I was not a public employee when I took on this endeavor. I was in private practice the entirety of my life. The reason why I applied for this position, and the reason why I'm running to continue in this position is to give something back to the community that has been so good to me and my family for the last 32 years. Thank you for the opportunity of allowing me to speak to you this morning. I look forward to the questions that I'm going to be asked and answered.
My name is Kerri Maxey. I'm the daughter of a Vietnam veteran. He served in the Navy. My mother worked in the medical industry as a laboratory x-ray technician and also an EMT. I am also a daughter of divorced parents. My parents' divorce was extremely bitter. It affected me as a child, and it still affects me today. After my parents' divorce, my mom raised me as a single mother. We lived paycheck to paycheck. There was about 3 winters where my mom heated the house with the oven because she couldn't afford to fix the furnace. I put myself through school. I worked as a housekeeper at a railroad lodging. I delivered pizzas. I worked in a deli, and my favorite was working as a cashier at a gas station. I am a public servant. I've dedicated my profession to only giving back to my community. I am running for judge because about 2 years ago, I was with a coworker and I was complaining about the judge's decision, and he told me to stop complaining and to run. So here I am today.
Thank you. So each of the panel members are going to ask a question. They will identify themselves before they ask the question, just so you, again, know who they are. If you're like me, you can't see that far to read their name placards that are sitting in front of them. But we're going to go ahead and start with Jim Jonas. You have about a minute to answer the questions. And again, Jim will let you know when your time is running short. Mr. Jonas.
Thank you, Jim Jonas, Director of Veterans and Politics. I want to thank both candidates for coming in. This question's for both of you. As I'm sure both of you know, Veterans and Politics has been very instrumental in trying to hold the family court accountable, because there is a lot of corruption in that court system, and justice delayed is justice not served, and most women in general bankrupt themselves in family court because they keep having to go back to the court and all the stuff you guys make them go through. Judge, what will you do? You said you would streamline this process. Give me an example of how you're going to do that.
Okay, Jim, I didn't use the word streamline. I said I'm trying to get people through this process as quickly as possible. The reality of the situation is I've done this 30 years. I have seen people that have been in this system for not 1, not 2, not 3, 14, 15, and 16 years. Okay. What I do is we have policies and procedures. We have procedures that we're required to follow. One of the very, very important procedures is a case management conference pursuant to NRCP Rule 16.2. And you guys may not know what I'm talking about. I get the parties in along with their attorneys, whether they're represented or not. I get them into my court. I require them to give me information on what's actually going on in the case. So I have a very good idea early on in the case as to what's going on. I take it one step further. I make comments. Don't make decisions. I make comments on how I think the law would apply to certain issues in their case. From that point, they leave court and they have a pretty good idea as to what's going to go on. And I try to get, and more importantly, I set cases for trial. I was a trial attorney. I tried hundreds and hundreds of cases. As a judge, I enjoy trying cases. So this isn't a situation where people are going to sit in before department end for years at a time waiting for a judge to make a decision in that case.
Yes. So I understand how stressful it is for a family in crisis to be going through the legal system, and to have that legal system take forever. I have an example with a juvenile that I represented. I appealed his transfer case to the Nevada Supreme Court, and the Nevada Supreme Court took 6 years to make a decision on my appeal. During that time, my client was in CCDC waiting for their decision for 6 years. He grew up in CCDC. Honestly, I wanted to call CPS for neglect on the Nevada Supreme Court, but I was not able to. So quick justice is important, but it has to be fair and impartial. And that's what I will do my best to provide for the families in our community, is their day in court. Thank you.
Commander Haynes.
Andre Haynes, Armed Forces Chamber. This is for both of you. How do you plan to ensure a fair and efficient process for child support determinations within the District Court Judge Family Division, balancing the financial responsibilities of both parents while prioritizing the child's well-being?
Do I go first every time?
No, we can take turns.
Yeah.
Thank you for that question. So the law provides with a basic formula that you have to apply to each case. I would do that impartially and apply that formula to the facts of the case. And also, while doing that, I'd always make sure that the child's best interest is at heart, because that's what family court is all about, is protecting the children and also assisting families in crisis to have a safe environment so they can peacefully resolve their disputes.
Commander Haynes, you asked a very relevant question to this election. You see, I don't think my opponent's ever done a family court case where she's had to actually argue child support. I did hundreds, and as a judge, I've probably done hundreds already in the last 10 and a half months I've been on the bench. The statute, we have statutory authority that tells us what we have to do. One of the first things we have to determine is what are we going to do with custody, okay? Right now I'm talking about physical custody. Are we going to award possibly sole physical custody? Are we going to award primary physical custody? Or are we going to award joint legal custody? Once we make that determination, which is the first determination we have to make, then we go to the Nevada Administrative Code, which tells us the applicable percentage of gross monthly income that applies to a child support obligation. Depending upon the designation of custody, from that point we apply the statutes and the case law to determine what the child support obligation is. Of course, we're always trying to do fair, so we're also given about 12 or 13 factors that we can look at to make a deviation from the statutory amount determined.
Thank you. Patsy.
Patsy Brown, Armed Forces Chamber. This question is for both of you. Adoption proceedings often involve intricate legal processes. How do you intend to navigate and simplify these processes within the family division, promoting a supportive environment for families looking to expand through adoption?
I think it's my turn. Yeah.
Yes.
Are we also ready?
Yeah, we're going to just alternate back and forth.
Very good question. I think we have to keep in mind that I believe the primary focus of the family court in handling child issues is the best interest of that particular child that we're dealing with, okay? So when you're talking about adoptions, we have statutory framework, statutory procedures that we are required to follow. I think one of the keys to adoption is to take into account that in evaluating the best interest of a child, typically permanency is one of the most important determining factors in setting forth what's in that child's best interest. Okay, so what we need to do is we need to look at the statutory requirements, the statutory procedures. We need to evaluate, and I don't know if people understand this. Before you proceed to adoption, you have to have a relinquishment and or a termination of parental rights. So that's the first steps in the process. But once we get past those first two steps, what we're really talking about is a best interest determination. Look, we do a lot of negative things in the family court. And what I mean by that is we deal with negative things. Adoption is one of the most positive things that we deal with. So it makes you happy to proceed with an adoption.
I actually agree with Judge Gaudet. Adoption is the most happiest time in the family court. You can always tell when a child is being adopted. The adults come in happy. The kids are always dressed extremely nice. It's the smiles on the face is just amazing. However, for adoption to occur, yes, the parental rights have to be terminated. And that's a serious decision to make because that is a constitutional right that is being decided. A parent has a constitutional right to raise their child. However, sometimes that parent isn't suitable and cannot raise their child. And if we can have another adult step in and adopt that child and become that child's legal parent, that is the happiest day in the courtroom.
Hi, my name's Donna Darden. And my question is, your jobs, when you're dealing with families, it's a difficult situation because you're dealing with a lot of emotions and things like that. Would you share with us that one case that kept you up at night? What you decided to do to remedy the situation?
And we're going to start with Ms. Maxey.
Thank you for that question. I've had several cases that have kept me up at night, but there's one case in particular that really truly kept me up at night. The mother and the parents were teenagers. They did their best to co-parent. The mom had custody of the child. There was no formal decision on custody. However, the mom overdosed. And because the child was with the mom, CPS stepped in and took custody of the child and placed the child with her natural father. However, the maternal grandmother was upset with CPS's decision and filed for guardianship and custody over the child. While this child was living with her teenage mom and her maternal grandmother, there was severe dental neglect. to the point where all of her teeth had to be taken away. I represented that child and made sure that she stayed with her dad and protected her constitutional right to be raised by her father.
You see, once again, you hear a response from the juvenile system. I was in the trenches with domestic cases. I'm going to give you two names, Donna Hernandez and Marina Cannon. It's two ladies that I was involved with over 20 years ago that were actually murdered in divorce cases and in child custody issues. Marina didn't have children with the guy. Talk about keep you up at night. Okay, these cases kept me up at night. There were situations where we were dealing with contempt issues. One of the situations I'd had the soon-to-be ex-husband put in jail, I think 2 times. They let him out, and he still killed my client. And before he did, she had looked me in the face and said, "Paul, we're going to do everything we can, but he's going to kill me," okay? And that affected me. I found out like on the day before Christmas Eve that he had murdered her. So what I've done to help, I take domestic violence very, very seriously. And I, as a practicing attorney, and now more so as a judge, I look for the facts. Now, it's a very serious allegation, okay? And the facts need to be proven, but I take it very, very seriously. And as a judge, if I'm going to err, I'm going to err on the side of caution in domestic violence situations every time.
Rob.
Rob Lauer, Veterans of Politics. Family court has a history of, frankly, dragged out, vexatious litigation. What will you do to streamline and make it more efficient so people don't go bankrupt trying to resolve family issues?
Thanks for the question. I'm going to answer it to you this way. I wish you would go out in the community and speak to attorneys who appear before me right now. One of the issues I had when I accepted this position was the length of time that the court system, and I don't want to point the finger at any particular departments, okay, but the length of time that the court system is requiring people to get through the family court system. I vow not to let that happen. I have now been on the bench 10 months. There has not been one time where I've taken more than 4 days to issue an opinion in a case. Check downtown, 30 days, 60 days, 7 months to issue an opinion. I will not let it happen. I'm talking termination case was a very difficult case to resolve. But what I do is, as I said in response to the first question, streamline may be the right word. I get people before me. I am not lazy. I'm willing to try cases. I enjoy trying cases. I try to direct them to the relevant points so I can get them through the system. And more importantly, I explain to them the importance from sanity perspectives to get them through the system as quickly as possible. Thank you, Jim.
So the decision to be made on a case, it depends on the case and the complexity of the case. However, you have to keep in mind that you can't allow your decision to just wait because it could be detrimental to the parties. As example, like with that client where I appealed to the Nevada Supreme Court. So I would take my time because I think I would want a judge who's listening to my case to take the time, look at all the facts, and apply the law and not shoot from the hip and not make just knee-jerk reactions or knee-jerk decisions. Each case would be treated individually. I would look at all the facts, be impartial, and make my decision in a timely manner to make sure that record is clear and concise.
Mr. Friend.
Frank Friends, Veterans of Politics, Family Court Observer. I'm a pro se litigant. I tried my own case. Took me 5 years, but I won and terminated rights of the mother. 27 violations of the court order, UTIs, constantly having our daughter in and out of the hospital whenever the mother had her, multiple failed drug tests of the mother, and it took 5 years for a judge to finally say, that's about enough of that. Statistically, children raised by single fathers do better than children raised by single mothers. But yet there's no court streamlining this. There's no court looking for the best interest of the child. How will you change that and look for the best interest of the child from a statistical standpoint and take any biases you may have from your upbringing out of it?
Well, I don't think you should ever have any of the biases of your upbringing coming into the courtroom. That is completely unethical. You have to look at each case individually, look at all facts individually, and create a solution to the problem that is before you as quick as you can. I'm all about the best interest of the child. I don't care about which parent is, whether or not it's the father or the mother. It depends on the parent. It's the parent that's most suitable that matters, because that is the best interest of the child. And to allow a case to be dragged out on and on, it's detrimental to the child and to the parents.
Well, there's been 3 questions now regarding time. I almost feel like I'm being blamed for the time frame. I give you my assurance. I move these cases through the system as expeditiously and efficiently as I possibly can. But I think to get to the crux of your question, when I prepare a case, this is how it happens. The case is set for a hearing. I have a law clerk that briefs the case. The first thing I do is look at the brief of the case. Just so you know, I don't look at names of the parties. I don't look at names of the attorneys. Now, when you start reading pleadings, you can tell the difference between the mother and the father, okay, when you get into the pleadings. I try to do this as objectively as I can, as concisely as I can to move people through the system. You named drug test. You said drug test, okay? We have the right, and there's a question, but we refer people to drug tests. You test dirty for certain drugs, there's going to be consequences. You violate orders in my courtroom, ask people about Judge Gaudet around town. There are consequences to violating the order. Otherwise, if I don't enforce my orders, I create chaos in society. Judge Gaudet is not going to create chaos in society.
Tara.
Terry.
Go for it. Thank you.
Terry Kellogg, the Democratic Party. I'm getting ready to just speak. May I ask 2 questions? One of them is in addition to the child support question, and then I have an additional question if the judge...
Okay, so we'll go ahead, but we're going to have to probably cut the responses to the questions a little bit shorter. We are getting a little bit tight on time. So if we could...
Just one. Just one.
So let's just get directly to the point without any...
There are child support payments that are in arrears. There are alimony payments that are in arrears, and there are judgments that are just never paid. What do you, as a judge, or how do you enforce that? And is there ever a time for, at the end, jail? How long does it take for jail to occur?
Super question. The attorneys in town will tell you, Judge Gaudet announces from the bench, 0 tolerance for non-payment of child support. 0 tolerance for non-payment of alimony. A lot of these cases, when it comes to collection, they're assigned to the district attorney's office for collection. I want them all to come before me, because I look people in the face and I say, once again, chaos in society. If you don't follow my order for child support, there are consequences. I find you in contempt. Monetary sanctions, jail time. I have the right to put you in jail 25 days for each and every time you violate the content of my order, and I have every intention to do it. It's civil contempt. You can purge your contempt. All you have to do is pay your child support. And I wish we as a court system, we enforce that harder, more often, because we wouldn't be dealing with a lot of the situations that you're making reference to right now.
I think it depends on the situation. If a parent is purposely refusing to pay child support, then yes, you should have zero tolerance. I agree with Judge Gaudet on that. However, if a parent is on hard times, maybe their job is seasonal, so during their off season they can't pay child support, I think you have to have some understanding and leniency in that. But if it's just a person that's purposefully not paying child support, not paying alimony, not paying what the court was ordered them to pay, then I agree, 0 tolerance.
Our last question will be from Barbara.
Hi. Hello? Oh. Hi. There's always a time in our lives, where we have to make a decision in our careers that will impact people around us. This is for both of you. Describe the moment that you actually decided, hey, I want to run for this position. What was... Bring us back to that moment.
I'm sorry, I forgot. It was about 2 years ago. I had a case in front of a judge, and I did not agree with how the judge held that case, with the decision she made. I had heartburn. I was so upset. I didn't feel that the judge made her decision in the best interest of the child. It felt like she was more following what the attorney was doing and not what the pro se litigant needed or what the child needed. So while I was complaining to my coworker about it, my coworker basically told me to stop complaining and go run. If you don't like how these judges are making decisions, go be a judge and make those good decisions.
I'm going to give you 3 moments. I tried a case before Judge Denton, a jury trial about 15, 16 years ago. He's an excellent judge. My dad used to love to come into court and watch me put on cases. The case concluded, the jury came back, and my dad looked at me and said, if you ever become a judge, you need to be like that guy. 2 or 3 years later, I put a case on before Judge Tim Williams. I brought my kids in to observe about a half day of the trial. And my kids were so excited. They weren't excited about Dad. They were excited about Judge Williams, who's also a really good judge. And then the third instance, he's now retired, but there's another attorney in town. He was a friend. We're opposing one another. We're on opposite sides of the bench. And they had a judge, and the issue was modification of alimony. You have to do an economics needs test pursuant to statute. And I'm going to be honest with you, this judge had no clue what was going on. And the other attorney from across looked at me, and it was comical but sad. Comical but sad. And at that point, I decided it was something that I wanted to do, to be honest with you. And so I hope I answered your question.
Okay, well, I'd like to thank everybody for being here today. Judge Gaudet, you're going to have about 1 minute and 30 seconds to let our panel members and our audience know why you're running to retain your seat.
Thank you. Paul Gaudet, District Court Judge, Department N. Thank you, Ms. Maxey. I had never met Ms. Maxey before, maybe a week ago, I believe. So I fully respect her. I'm not here. But I want to point something out to you, okay? I am a family court judge. Do you think it's more likely you're going to appear before the criminal bench? Do you think it's going to more likely you're going to appear before the civil bench or in some high dollar case? Or do you think it's more likely that you're going to appear before a family court judge? The reality of the situation is 50% this was 10 years ago, 50% of the marriages in the United States of America were ending in divorce. We live in Nevada, 6 weeks of residency. We probably have a higher percentage of that. I don't know how many of you are married. I don't know how many of you have children. I don't know how many of your children are married. I don't know how many of your friends. But in all likelihood, you have a much greater chance of appearing before a family court judge than you do anyone else, any of the other judges. Ms. Maxey, with all due respect, I know nothing about you, but I understand you're a member of the Public Defender's Office. I have a family court docket. I would venture to say that Ms. Maxey has never done a family court case in her life, yet she is running for Department N,
okay, so I just need to know
family court docket.
Why you're running in your closing statement. That's not about anybody else.
I appreciate that. I'm running to serve the citizens of Clark County, Nevada. Thank you very much.
Ms. Maxey.
Thank you, Judge. Thank you, panel. Thank you, everybody in this room. It's been an honor to go through this process. Children have been the heart and passion of my legal career. I have been a champion for children. I have protected their constitutional rights, their legal rights, and their voice. I believe I am the only attorney in Clark County that has represented a child in delinquency, dependency, guardianship, and custody. Now, you've listened to Judge Gaudet, and you've heard me, and I know you've all done your research on us too. Today you have a choice. You can choose to endorse status quo, or you can choose to endorse a champion. Thank you.
Okay, thank you everyone for being here. I'd like to once again thank our sponsors, Monzu Italian Oven and Bar, Stephanie Phillips, U.S. Senate candidate, and an anonymous donation on behalf of Jerry Willock. To our panel members, thank you very much. To our candidates, thank you for being here, and good luck. think we're going to head downstairs for a quick photo with everyone. Thank you.
Thank you.